Now, Mr. Hussain, if I could make a comment before you begin your submissions. It's struck us that the approach of the courts below and tribunals below at all levels seems to have been somewhat difficult to reconcile with the statutory framework. And we'd quite like to get ourselves on the right footing. This is a statutory appeal, is it?
My Lord, yes.
It's not a judicial review.
My Lord, that's right.
And what are the statutory grounds of appeal that are available?
So the Secretary of State's decision that Section 232(5) of the 2007 Act was not in accordance with the rules, the law, and that removal would be contrary to Article 3.
Yes. I thought the grounds of appeal under the statute were only either a breach of convention rights, yes, or a failure to follow the immigration rules.
That's the position following changes made in 2014, yeah, to the governing regime in the 2002 Act.
Yes.
In this case, it was the previous regime that applied, and I can take you to passages which make that very clear.
Oh, I see. And is that because although the FTT decision was in 2015, is it because the
transitional provisions?
The transitional provisions, because this was a pre-2014 Act decision of the Secretary of State?
Exactly. That's
right.
The gist of it.
Right. So are you able to take us to what are, for our purposes, the relevant grounds of appeal under the statute?
Yes, of course.
This would be the old Section 80...
Section 80, it's still Section 82. It was completely rewritten.
Right.
So, but I can still do that.
Yep.
My Lord, before I go there, can I just ask you whether you'd like to hear submissions from me about anonymity?
Oh, yes, of course we should deal with that. No, we don't need to hear you on that. We've read the material submitted in writing, and particularly in the absence of any opposition on behalf of the Secretary of State, we're content to make the order. So the court is making an order that no one should publish or reveal the name or address of the appellant who is the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the appellant or of any member of his family in connection with these proceedings. And that order is being made in order to protect the appellant's safety in the event that his appeal against deportation ultimately proves to be unsuccessful.
My Lords, my Lady, thank you very much. So, my Lord, I'll go straight into the relevant Act then, if I may. Yeah. So it's the 2007 Act I'll begin with. That's Volume 1, Tab 3 of the authorities. So are my Lords and my Lady all electronic? I'll just give you EF numbers. So it's EF 680. And many of you will be familiar with this. So Section 32 provides for Section 32 provides for automatic deportation. The interesting provision for my Lord's question is that at EF 683. 35.3, which adds into, or added rather, into Section 82.4, General Right of Appeal, insert the following, and that had the effect that a decision that 32.5 applied became an immigration decision that was appealable on general grounds. And we see that. And in this case, the Secretary of State took the 32.5 decision in March 2013, and you have that at EF 197. So that was the decision which gave rise to the right of appeal, and the governing appellate provisions were in the 2002 Act, pre-amendment, at EF 669, and the appeal here was brought under 84.1a rules. So that is Rule 3390.
Well, we'll come to that.
We'll come to that in a minute. Law,
yep.
That would be the qualification directive. You don't need directly effective provisions of the qualification directive. You wouldn't need that, though, because there was transposition. And then...
I'm sorry, again.
Sorry, Mother.
Oh, I see, that's E.
I didn't give... It's
yep.
completely my fault. I didn't give the subsection. So 84.1a, E, and G. And G, Refugee Convention or Convention rights. The Refugee Convention ground couldn't succeed because of a different provision in the Act, Section 72, which you have at 663. That is on the basis of Article 33.2 and the presumed commission of a particularly serious crime constituting a danger to the community of the UK, and that presumption wasn't rebutted on the facts, and that had the consequence that the Refugee Convention ground failed. There's an interesting question about whether or not the individual there retains the status of a refugee. We don't need to get to that, because that is all about negating the refugee's right to non-refoulement rather than negating the status of refugee itself.
What's the, which is the part of Section 72 that which implies that he doesn't qualify for protection under the convention? Oh, I see. Is it really just the fact that he's...
10, subsection 10.
Oh, I see. That's on the next page.
If in agreement that the presumptions apply, must dismiss the appeal insofar as it relies on the ground specified in 9A, and 9A is removal would breach UK Refugee Convention obligations.
Sorry, you're reading from?
I'm reading at page 664, my lord. So
664,
9A. EF 664, I first read subsection 10, B, if the tribunal agrees with the presumption, it must dismiss the appeal on the ground set out in subsection 9A, which is the Refugee Convention obligation ground.
I see. So in terms of subsection 9A, the appellant was somebody who appealed under section 82.
Yes.
Partly on the ground, but to remove him
yes.
would breach the UK's obligations under the Refugee Convention, and the Secretary of State issued a certificate under 9B, I take it.
There wasn't a certificate, but my Lord Justice, Lord Hamden may recall a case where my Lord decided, it's a case called MS Somalia, from memory, where my Lord decided that you didn't have to have a certificate formally issued. The tribunal was nevertheless required, when the issue was raised, to apply this section. Therefore, going back to the grounds of appeal, if you look at 669...
I'm sorry, you're saying a little bit fast for me. So in the absence of a certificate, you would have to work out whether one of the relevant presumptions applied.
Yes.
Under subsections 2, 3 and 4.
Yes, and the FTT did that and held that they applied. They weren't defeated.
And you say, Mr. Hussain, that leaves open the question whether a person is in fact still of refugee status and entitled to protection of the Convention.
Well, it does. I don't want to get into that. Can I explain to you why? I'll give you a bullet point now.
Please.
The reason is what Section 72 is doing is construing Article 33.2 of the Refugee Convention. Article 33.2 is the provision which says you don't get the benefit of the biggest protection that refugees have, i.e. non-refoulement. That is disapplied, but you're not then excluded from refugee status itself. So the states may have other obligations to you under the Refugee Convention.
Thank you.
But as appeals, so far as based on the Refugee Convention, would inevitably be dismissed.
Exactly, because of this statutory direction.
Yes.
And the appeal was limited to refoulement, is that right? The obligation.
Yes, I'm not. I don't want. It's no part of my case here that my client is a refugee. I don't need to make that case. I don't make it. My position would be, if the case goes further at any point, that he is.
Right.
It's actually fairly clear that he is. I'll show you the Refugee Convention when I develop my argument on the issue A.
But you say it's immaterial to the issues we have.
It's not material to any of the issues. The issue here. Sorry, if I go back to the grounds of appeal, the ground that is most pertinent for our purposes today is the second limb of 84(1)(g), and that is Article 3.
Yes.
And we see that at EF 560, that these were the grounds that were raised. You'll see the Refugee Convention ground wasn't raised in terms, but it was said that the appellant should retain his refugee status. 560. I'm sorry, it's extract, so it's not very clear what this document is.
What's this document?
It's the grounds of appeal
To whom?
to the FTT.
To the FTT.
I'm sorry it's been extracted in this way. It shouldn't have been. And you'll see the decision is wrong in law, rules, policy is irrelevant. And then the decision potentially breaches 2, 3, and 8. And the particulars at 2, he should retain his refugee status. Not material. Not material.
So in the light of Section 72,
Yes.
which you've just taken as, why are the courts and tribunals concerned
Yes.
with the question of alternative location?
Because it's common ground. My learned friend's phrase is equal cogency. The doctrine of internal relocation applies with equal cogency, as my learned friend puts it, to Article 3.
Why?
There's case
It's got
law.
nothing to do with Article 3.
No, my lord, that's not right.
Article 3 is
Firstly,
inhuman and degrading treatment.
It's not right as a matter of law, and it's not right as a matter of what is common ground here, and it's not right as to
Well,
how...
we're not interested in common ground. Our function is to try to clarify matters in a case that seems to be a cloud of confusion
My lord,
for lower courts and tribunals. So why in law does alternative relocation
we've
have a
given
bearing?
you in our printed case... At EF 61, footnote 25 a list of Strasbourg cases, and I can take you to them, where they apply internal flight. We've given you Human Rights Committee communications under the ICCPR, where they apply IFA as a basic rule of international refugee law and international human rights law. And we've made the point that the Secretary of State's position has always been that it's the same approach.
Well, you'd better take us to at least one of these authorities.
I'm happy to do that. But can I also say that if we were in the modern appellate regime, your Lordship's observation to me would be absolutely right. Doesn't matter what the policy is, it's Article 3. That's not the position here, because we had the rules and we had the law. Well, the
rules and the law, I thought you were just talking about Article 3.
I am.
Right.
And it is the position, both as a matter of law and as a matter of the Secretary of State's policy, that the same approach applies to internal relocation under.
Well, there's a difference between an appeal on the basis of a breach of Article 3 and an appeal on the basis that the Secretary of State has failed to comply with her policy.
Yes, and both were run here. We just saw that.
Well, we've looked at what the relevant grounds of appeal are under the statute.
Well, my Lord, I just showed you.
There's nothing about policy there.
Yes. Oh, well, there's a case from 1996 called DS Abdi, which held that policy, that law included departmental policy. That was in 1996.
When you told us about law, you said that was to do with breach of a qualification directive. Are you now saying, I mean, was there a ground of appeal based on
policy,
error of law to do with a failure to follow policy?
Yes, 560, top of the page. I'll just show you the document.
Right. Wrong in law, not being in accordance.
The decision was wrong in law, including not being in accordance with immigration rules and policy. But I very much recognise your Lordship trying to organise the issues in this way. I completely understand why my Lord is interested in that. Our case, there's no problem with accommodating it under the correct rubric, even if we were in the modern regime. For the reasons I gave you, under the ECHR, Article 3, a doctrine of internal flight is applied, which Mr. Malik accepts is the same. And it's the Secretary's policy as well that in Article 3 cases, when you look at internal flight, you go to the rule which applies to refugee and qualification directive cases. I'd better show you that.
Yeah.
So that rule.
I mean, I'm also wondering on what basis a failure to follow a policy is an error of law. I mean, I would normally be talking in terms of legitimate expectations, perhaps.
Well, you would be before cases like Lumba, Kambadzi, and so forth. But certainly those cases is another case.
But they can't transform policy into law.
Well,
the whole point of the policy is you're not bound by it. You know, British Oxygen and Board of Trade.
Yes. Policy is indicative. Law is prescriptive. It dictates what you've got to do. Of course, you can follow policy. You can refuse to follow policy for good reason. But if you haven't got good reason, it's an error of public law. That's what, irrespective of legitimate expectation, that's what cases like Kambadzi 10 years ago, Lumba 10 years ago decided, as my Lord well knows. So, and certainly in this regime, it was well settled even before those cases, that if you didn't, the Secretary of State failed to follow her policy without good reason, that's a critical qualification, my lord, then the decision would be not in accordance with the law. It's a 1996 decision called DSW. We haven't got it because it wasn't a live issue, but I can get it for you.
Right.
And then I can
So
also...
does this appeal really have... I'm still trying to get clear in my mind what this appeal in legal terms is really about.
Issue A, the legal question is, what is the correct approach to internal relocation in this case?
And you say the issue of internal relocation arises in the first place because of a policy of the Secretary of State's.
Yes, and also that I say it arises through it arises in this case for three reasons. Firstly, policy. Mm-hmm. Secondly, it's how everybody has agreed it should be argued, not just as a matter of policy, everyone's followed it. And thirdly, that is also the position in law. So,
in law...
as a matter of Strasbourg jurisprudence.
Right. So really there are two limbs to this as a matter of law. Firstly,
yes,
you say under Lumba, the Secretary of State has to abide by a policy, and there is in the absence of a good reason to depart from it, and that's a public law duty. And in the present case, there is a policy of considering something to do with internal relocation.
Yes, and the third point is that...
secondly, the issue arises under Article 3, you say.
Yes, yes. So, my lord, can I take you to the rule which the Secretary of State says should be applied in Article 3 cases, firstly, and then I'll take you to the policy, if I can do it that way?
Yeah.
So the rule is at EF 695.
Yes. I mean, this isn't a rule to do with deportation at all.
To do with...
It's not a rule to do with deportation.
Yes, but if you remember, I went too quickly through the Act, the 2007 Act. The 2007 Act stipulates exceptions to the requirement automatically to deport. One of them is breach of Human Rights Convention. That's rights at the executive level. And then at the appellate level, I showed you how that decision, the automatic deport decision, is appealable on general grounds of appeal. And one of the general grounds of appeal is that you're going to breach Article 3, let's just say that, or the Refugee Convention. If you look at the rule talks about when you will get asylum under the Refugee Convention or humanitarian protection under the Qualification Directive in the context of internal relocation. Yeah. And then the policy will tell you that you apply the same approach to Article 3. Does my lord follow? This is not about deportation, you're right.
No, so how does this rule apply to the appellant?
Can I show you the policy at EF 1238? It's all set out in our case as well, if you'd like it. And that's at paragraph 28 at EF 61. We've set it out like that because it just has never been an issue. Otherwise, you'd have had a lot more on it in writing, my lords, my lady. So, sorry, the policy is at 1238. It's 3. So it begins at 1233, considering human rights claims. If you look at 1233, at the bottom of the page, internal relocation, and then we've extracted that.
Well, and what's this document we're looking at?
This is the Secretary of State's policy. It's a departmental policy.
So this isn't an immigration rule?
No, it's not, but it's the policy which says go to the rule, internal relocation, at the top of 1238. All it says is see the AI, that's the instruction, asylum instruction, on internal relocation and paragraph 330. I showed you that. And then the instruction is at the next page at 1239. And this says, under 3390 of the rules, the question to be asked is whether the claimant would face a well-founded fear of persecution or a real risk of serious harm in the place of relocation, and whether it's reasonable to expect them to travel to stay in that place.
But this is all headed up in 8.1 to qualify for asylum or humanitarian protection. We're not dealing with either of those.
Correct, but if you look at 1233, which I showed you earlier, bottom of the page, the heading is Article 3 ECHR,
yes.
Then the final entry is internal relocation, and I showed you at 1238, caseworkers by policy say, look at AI on internal relocation and the rule.
Yeah.
So the Secretary of State's policy is that the rule, which I showed you, 3390, applies to Article 3 cases. None of this is controversial. Mr. Malik says in his case, at paragraph 21, that this doctrine applies, quote unquote, with equal cogency to Article 3.
Yeah.
That
but
was
but
also
the more surprising proposition is that it applies not only in the context of asylum or humanitarian protection, which is what 3390 is all about,
yes.
but it also applies in the context of deportation.
Oh, the reason it applies in the context of deportation is because if you have a refugee claim, humanitarian protection claim, or an Article 3 claim, it's inconsistent with those obligations to remove you. That's, with respect, straightforward.
Well, so you say.
Humanitarian protection doesn't apply in this case because of the risk of...
You're absolutely right. You're absolutely right. So it doesn't.
There was no claim for humanitarian protection.
One never applies for humanitarian protection, and the reason for that is that a condition precedent of getting it is that you failed in your refugee claim. So you always apply for refugee status. If you lose that, then you could get humanitarian protection. Yeah. In this case, the reason why my client was excluded from refugee protection, and the bit I showed you, is also a reason why be excluded from humanitarian protection. So the only obligation in play is Article 3. I fully accept that. But the courts below...
So therefore the rule 3390 doesn't apply...
On its face.
On its face.
On its face it doesn't. Departmental policy says it does. And I'll give you references, if I may, in the courts below where exactly that approach was taken. And it's upper tribunal at paragraph 3.1 at EF 160. So EF 160. So the Secretary of State's grounds of appeal are that the first-tier tribunal judge didn't apply the proper test in Januzzi. Januzzi is a refugee convention case. That was the Secretary of State's grounds. And at 15, paragraph 15, the upper tribunal applies 3390, and then Lord Justice Ryder in
The concepts of paragraph 15 are a little bit...
They are. You're right. You're absolutely right. It is not part of my case that my client is entitled to humanitarian protection. That's a gloss. It could well have been expressed more clearly. I accept that. But it doesn't alter the position that this is how the doctrine was applied. It was applied as if it applied to Article 3, because that is the Secretary of State's position in these proceedings, also as a matter of policy, as I've said. And then at Court of Appeal, Lord Justice Ryder at EF... We've given you the weekly law reports version. Can I take it from there?
Yes.
Thank you, my lady. And this is at paragraph 34, 2508. So third question, the three questions are set out at 33. Is it reasonable, not unduly harsh, to expect the person to relocate? And that involves value judgment 3390 and Yunuzi.
Yeah.
And then I better take you to the Strasbourg case.
I mean, your reading of that, I'm far from persuaded that that's a correct approach in law.
Can I seek to persuade you why it is?
Well, can we just take things one stage at a time? At the moment, so far as policy is concerned, you've told us that internal relocation and what's said about it in the policy document you showed at is really treated in the industry, if you like, as applying to deportation as well as asylum and humanitarian protection claims. So far as the other basis of the appeal seems to be Article 3. Now, so far as that's concerned, I'm looking at the first of the authorities that you cite in footnote 25 in your case, EF 61, which is DNM and Sweden.
Yes.
At paragraph 59. Now,
yeah, I think that's at EF 1997.
yeah, we just look at that. It's 1995.
Yeah.
The passage, the section begins dealing with the possibility of internal relocation, and we can see it. We're told the court reiterates that Article 3 doesn't, as such, preclude contracting states from placing reliance on the existence of an internal flight or relocation alternative in their assessment of an individual's claim that a return to the country of origin would expose him or her to a real risk of being subjected to treatment prescribed by Article 3. However, the court has held that reliance on such an alternative doesn't affect the responsibility of the expelling contracting state to ensure that the applicant is not exposed to treatment contrary to Article 3. Therefore, as a precondition of relying on an internal flight or relocation alternative, certain guarantees have to be in place. The person to be expelled must be able to travel to the area concerned, gain admittance and settle there, failing which an issue under Article 3 may arise. The more so if in the absence of such guarantees, there is a possibility of his or her ending up in a part of the country of origin where there is a real risk of ill treatment. Now that's exactly as one would expect.
And then, my lord, if you go to paragraph 59,
Yep.
1997, it's a bit Delphic, but there are other cases which expand on this idea of reasonableness. So, having regard, internal relocation inevitably involves certain hardship, not least in a tribal-based society. Nevertheless, having got regard to what's been stated above, there's no indication the applicant should be unable to find a relocation alternative in southern Central Iraq where living conditions would be reasonable for him.
Yeah.
He's a young man without any health problems.
But this
Could I
is
just
still,
ask you to go forward?
well, if you just go on to paragraph 60,
Yes.
thus the court concludes that substantial grounds for believing that the applicant would be exposed to a real risk of being subjected to treatment contrary to Article 2 or 3, if deported, have not been shown.
Yes.
Now, there's nothing in what we've seen in that case that supports the idea that the standard under Article 3 is anything less than inhuman or degrading treatment.
Well, can I show you MKN, where it's a bit more full? I accept that's the ultimate question. My Lord, if I can show you MKN, and then I'll explain to you how it can textually be said that the idea of internal relocation can come within Article 3, just as it has been interpreted to come within the refugee definition. The fundamental point being, this is state practice. State practice in the 80s. That's where this came from, this idea. And that's obviously relevant under the VCLT. You were looking at that, my Lords, last week, I think, Article 31(3)(b).
Yeah. So the discussion begins on page 2029, paragraph 35, where it repeats what we just saw in the earlier Swedish case.
Yes. And then at 39, you'll see, again, internal relocation. So there's 2030, internal relocation inevitably involves certain hardship. Various sources have attested that people who relocate for the first time reason may face difficulties.
Yes.
For instance, in finding jobs, housing, not least if they don't speak Kurdish. Evidence before the court suggests there are jobs available, settlers have access to health care, as well as the financial and other support from the UKSC and other authorities. No indication that the general living conditions will be unreasonable
or amount to treatment prohibited by Article 3.
Or is disjunctive. It's disjunctive. It's very important.
But this is a case based on a breach of Article 3. There can't be any test lower than a real risk of inhuman or degrading treatment.
Well, you might think that to be the case.
Well,
also,
show us a case. Well, this is the case you took us to. Do you have a better authority than this one?
No, that is repeated in other cases, but I can take you to a decision of the Human Rights Committee if you'd like to go to it.
No. Well, I think we've made it pretty clear in recent decisions that we're not terribly interested in what the Human Rights Committee has to say.
They consider that I'm fully cognizant of my Lord's decision.
Yeah, because they're not carrying out the function that we're carrying out. Anyway, you're relying on Article 3 of the Convention. You're not relying on the
Article 7 of the ICCPR. No, I can't.
Is this the best you can come up with for Article 3?
For Article 3, that's the best that there is. For the observation that my Lord had a moment ago, that this doesn't lower the standard from inhuman or degrading treatment, exactly the same observation can be made about the Refugee Convention. The Refugee Convention definition does not have any reference to that it would be unreasonable in a safe area. What the literature shows is that in the 70s and 80s, states thought it was sufficient that you faced persecution in a part of your area to qualify. It didn't have to be countrywide, the persecution. Yeah. And by parity of reasoning, you could argue the same thing in the Article 3 context. And indeed, there were, I know you don't want to go there, there's a member of the Human Rights Committee, an eminent professor of international law, who has that view. So the question is, well, how do you get this doctrine into the Refugee Convention? Well, it's state practice in the 80s, and textual hooks have been identified after the event. Similarly, the governing concept in Article 3 in an expulsion context is causation. We know that from Lord Bingham and Fuller. States incur liability in the expulsion context under the ECHR because if they cause treatment that's prohibited, it's not through any other doctrine of vicarious liability or anything like that. It's causation. And we see that in the idea that nobody will be subjected to prohibited ill treatment. So similarly, just as in the Refugee Convention, Lord Bingham located internal flight in what he called the causative condition, why you outside your country of nationality, there is a parallel. It's not exact, because the object of the clause in the Refugee Convention is the individual. The object of the clause in Article 3 is a state. But it's the same idea, it's causation. So there is a textual hook. There is case law, we say, which supports the idea that the inquiry isn't just Article 3 ill treatment countrywide. It's Article 3 ill treatment in part of your country and are living conditions reasonable, jobs, healthcare, and so forth. The MKN case that I just showed you. So it is broader, just as in, and it's a heightened test, it's a stringent test, a rigorous test. We accept all of that. That is the position in refugee law. Just as in refugee law, you're a refugee protected by the principle of non-refoulement if you are at risk of persecution in part of your country and it's unreasonable or unduly harsh to go elsewhere. You meet the refugee definition there, and you're protected from the risk of from refoulement. So there's a parallel, we say, and as a matter of policy, that is the Secretary of State's policy. I didn't answer my Lord's question properly about deportation. I'm sorry. Deportation is no different because the statutory regime says that if you have an Article 3 claim, you can't be deported. Now, that is the same as saying, well, you can't be removed. Because the statutory regime does not draw a distinction either at executive level, Section 33 of the 2007 Act, that's the exceptions to the rule, automatic deportation. The Secretary of State need not automatically deport if to do so would be contrary to Article 3 Refugee Convention. And at the appellate level, we now have provisions which say you can't deport if it's contrary to 3 or the Refugee Convention. You can't remove either. And in our regime, you additionally had, you can't deport, you certainly can't deport under the 2007 Act if your decision is contrary to the rules or the law, which we say, if I need to make the submission, I will certainly make it, includes the policy. The policy is apply internal relocation. I entirely see the force of my Lord's difficulty with this doctrine. If I can confess, I had the same issue, if I may say so.
I think you've done very well, if I may say so, in trying to explain the matter to us.
On a literal textual interpretation, it doesn't make sense. I accept that, but state practice, a concordant view, the WTO appellate body, state practice is a relevant interpretive tool. State practice is widespread with regard to the Refugee Convention. You've got it expressed in the Qualification Directive, and we've got it in the Strasbourg jurisprudence, and also, if you want, international human rights law, Article 7, you've got it in the ICCPR as well.
Yeah.
So state practice is the route through which this comes in. And after the event, scholars and courts have worked out where it goes in the definition. In an early case, a case called Robinson, in 1998, the tribunal argued that actually this was nothing to do with the Refugee Convention at all. Mr. Shaw argued for the tribunal this was nothing to do with the Refugee Convention. And Lord Justice Brooke, Lord Wolfe, held no, it fits in the protection limb of the Refugee Convention. If it's unreasonable for you to move, you can say you can't avail yourself of protection. That analysis then moved in a case called E, Lord Phillips, and was accepted by Lord Bingham in Januzzi that no, the proper location textually is in the causative condition why you outside your country of nationality. And if it's unreasonable for you to move from region A, where you'd be persecuted, to region B, where you wouldn't, if it's unreasonable, then the causal nexus between the persecution and your being outside remains intact. So he located it there. That's the position in our law. That's where it belongs. Other people say it belongs somewhere else. In refugee law, that's where it belongs. And I can draw an analogy with the driving concept of causation in Article 3 as well, because if you remember, there was a big debate about what articles apply in expulsion context. Lord Phillips in Ulla in the early 2000s. And Lord Bingham says, well, they all apply in principle, subject to flagrancy. Article 3 just applies, and the route through which it applies is causation. That was in Ulla around paragraph 18. And that's the analogy. And it's common ground. And I had a rules and policy argument.
Yes.
Could I just understand the mechanics of it? So what you're saying is that if there is an Article 3, a real risk of an Article 3 in the place of habitual residence in Jamaica, or generally in Jamaica?
No. On the findings that I have, the findings I have are that in...
But are you looking for a risk in a particular location which the individual wants to go to, or are you looking for a risk overall, or where? No,
the unit of analysis is a country, and it is enough if in part of Jamaica...
Any part?
Yes.
Any part?
In any part of Jamaica, there is a risk of prohibited ill treatment. So that on Article 3, inhuman degrading treatment, even torture. The finding was he was tortured, because ECHR applies an intensity test to torture, not a purpose test. It's not UNCAT.
So even if he's got no intention of going to that particular part of Jamaica, that the Article 3 risk would be there?
If, but only if, it's a necessary and sufficient condition, that it would be unreasonable in the sense of unduly harsh. It's a very high threshold if he goes somewhere else.
Well, obviously, you're going to take us back at some point to Rule 3390, and we'll be talking about, I imagine, what's meant by a person can reasonably be expected to stay in the context of that rule. But so far as Article 3 is concerned, at the moment, from the authorities, it rather looks as though what the European Court is saying is that the issue in relation to internal relocation is whether the person, whether the internal relocation is realistically a possibility for the person concerned, and if so, whether it's one which would not involve a real risk of treatment contrary to Article 3.
That's not the only question.
The questions about unduly harsh and the like simply don't arise under Article 3, so far as I can see.
Well, I mean, that's what we've been debating a moment ago. Yeah. You saw the references in the Strasbourg cases to whether or not living conditions would be reasonable. That's also the test under 330 and the Qualification Directive. It's been interpreted to mean unduly harsh. The reasonableness in the context of internal flight has been interpreted in the Januzzi case to mean unduly harsh.
Well, you're relying on the sentence that in any event there is no indication that the general living conditions would be unreasonable or in any way amount to treatment prohibited by Article 3. You're reading that disjunctively and saying that, well, even if there's no breach of Article 3, there's a wider question of whether living conditions would be unreasonable.
Yes.
Yeah, that's well, I understand that's how you're reading.
I'm entitled, if I may, please, to read it disjunctively. They could very easily have said, none of this matters. Why should it matter whether you can get support for it?
Well, it might be unreasonable for all sorts of other reasons.
Well, that's
for example, it's not reasonable to expect a man to take refuge in a nunnery. You know.
No, my lord. That raises a different question of what the test is. It doesn't go to the proposition that there is a test. There is another question that you ask. What my lord said a moment ago is, well, what's the metric? What are the relevant factors? Your lordship's observation goes to those sorts of issues. But because of the Strasbourg case law has developed, and as I said, this is state practice from the 80s, because of the way it's developed, it's clear, we say, that there is this test. We can argue about what it involves, and that's issue A.
So for example, I suppose you would say, if the part of the country in question was, I don't know, we'll say a different language perhaps was spoken, an area where he would have no prospect of any employment, social relationships,
yes,
and like, then you would say that would make it.
It could. You've got to look at all the circumstances as applied to the characteristics of the individual. A touchstone is whether or not you can live a relatively normal life by local standards. That's a touchstone. Fully accept it's a quote-unquote stringent or quote-unquote rigorous test.
Yeah, I see.
Lady Hale, stringent in A.H. Sedan. Lord Carswell, rigorous in Januzzi. Entirely accept that because of the context. So then, finally, we get to issue A. So before I do that, I had a preliminary point, which was, if I may say so, the Secretary of State's attempt in her case, right at the beginning of the case, to introduce material concerning the appellant's offending after the Court of Appeal decision. And we accepted in our case, I hope, clearly, the concern, the legitimate concern to which my client's offending history gave rise. And we also pointed, not remotely by way of excuse or justification, we also pointed to, quote unquote, the atrocity he suffered as a young boy. That wasn't my term, but that of the medical expert at EF 365, who with certainty, quote unquote, stated that my client was amongst the most vulnerable clients with whom she had ever worked. Certainly his offences had been grave, and she sought in no way to excuse them. However, before his offending, he was an innocent and brutalised, frightened child. That's at EF 449. The Secretary states her attempt to introduce new material, we say, is inappropriate for the following reasons. The obvious first point is that the relevant time for factual analysis was that of the first tribunal decision. Subsequently, all appeals have been on grounds of law, not fact. Secondly, if the Secretary of State is permitted to introduce new material prejudicial to my client, post-dating the FTT's decision, never mind the Court of Appeal, that I should be able to adduce evidence, a material beneficial to him, and the consequences are somewhat of a factual free-for-all. I could say, well, his recent offending is essentially driving offences. There's a complete absence of any violent offending, contrary to the way the Secretary of State puts her case. There have been positive probation reports, I'm instructed. There's been a hiatus in his offending for some 4 years or so, and so forth. To regret it, I should be able to say why the offending, regrettable as it is, occurred, and why it shows that the prediction in the 2015 documentation that the risk of committing a violent crime within 2 years, that's EF 171, paragraph 31. FDT, who allowed his appeal, said that noted that the risk of committing violent crime within 2 years was very high. That hasn't been borne out. If it's a free-for-all, then surely I should be able to say all of that. Indeed, I should be able to point to any factors which avail my client, if the Secretary of State can point to factors which countervail my client. So there are very strong policy reasons why the court shouldn't permit this kind of approach. Indeed, should deprecate it in our respectful submission.
I see the way in which the European Court summed up its conclusion in the case, the MKN case,
yes.
At page 2030, paragraph 40, was to say that it considered that relocation to the region in question is a viable alternative.
Yes. But I completely accept that this doctrine is most developed in international refugee law.
Yeah.
That's where it came from in the 80s. It's where it's been transported. It's gone into the qualification directive, and Strasbourg has picked it up. And in the Strasbourg case law, I accept it's Delphic. And if you didn't have that backcloth of international refugee law, one would think, well, what on earth are they on about here? What's this got to do with Article 3? I accept that. But the fact that they are looking at questions like jobs, housing, support, and they talk about living conditions being reasonable or not, it is a nod to this doctrine, which is, as I said, very fully developed in international refugee law.
Yeah.
And well, the last bit of the preliminary point I was making is the Secretary of State says that somehow she would be powerless if your lordships, my ladyship, were to allow my appeal and restore the first-tier tribunal's decision. That, of course, isn't the case. It would be open to her to, I don't invite this, but it would be open to her to seek to issue fresh deportation decisions if, as regards Article 3, conditions had changed as regards Article 8, if the offending was sufficiently serious in her view to prompt that. Two of your lordships may remember the case of Sandbar, and if you remember that case, Sir Declan Morgan, it's fair to say, considered that post-first-tier tribunal events should be looked at again by someone other than this court before deportation was effected. So therefore, we respectfully submit it wouldn't be right to have regard to post-tribunal, first-tier tribunal conduct. Issue A.
Just before you go
My
there,
Lord, yes.
at EF 147, paragraph 33.
Sorry, can you just give me a moment? I paper.
It's the Court of Appeal's judgment.
What paragraph, my Lord, sorry?
Paragraph 33.
Yes.
Should the second question then be Article 3, basically? Are there real risks?
Yes, you're absolutely right. That should have been the correct question.
It shouldn't be serious harm or
it shouldn't be serious harm because
persecution.
that's Qualification Directive Article 15. We know he's excluded from that. Or it shouldn't be persecution. They've used it interchangeably. Yeah.
And so you contest that the third question should be...
same question.
Should be the same question,
yes.
As opposed to if it was just purely Article 3 without this rider attached to it, it would end there.
It would end there, absolutely.
It would end at 2.
Yeah, 3 is inconsistent with a strictly textual approach to Article 3. It's inconsistent with Secretary of State's policy. It's inconsistent with how the case has been argued. I'm repeating myself, I think.
Okay. Thank you.
So, issue A. And I wouldn't normally do this, but your Lordship's ladyship will understand why I am. We just look at issue A in the SFR at EF 46, because there is some confusion about what the Court of Appeal held and what in fact is issue A. So issue A does a decision on interrelication import a value judgment, including consideration of that person's criminal conduct in the UK. Now, we say it's important to distinguish between two questions. Firstly, what is the standard for undue harshness? Is criminality relevant to that standard? How much hardship, as a matter of law, can the applicant be expected to bear to avoid harm? Is criminality relevant to the standard? Now, the Court of Appeal held that it is relevant to the standard because it informs what is due to the claimant, what he's got coming, as it were. Accepting the Secretary's submission, and the result is that exactly the same circumstances may be turned into a consequence that isn't unduly harsh by the factor of criminality, when otherwise it wouldn't be. And we see that from the Court of Appeal, in particular, at paragraphs 37, 39 and 40.
Did this arise out of a submission made on behalf of the Secretary of State, or was it something which the court itself?
Full frontal Secretary of State submission. A submission that is not defended today, and as Mr. Malik will, I think that's common ground, but he doesn't defend it. But he can say that.
Thank you.
In a communication that we had that I've been permitted to tell you about. It's full frontal, the Secretary of State's submission, and I can show you exactly why that was.
Can I ask? You obviously have a wide knowledge of the case law. The cases from Strasbourg that we've looked at don't contain any trace of this idea. They simply talk about, well, the phrase that's being used repeatedly is whether internal relocation is a viable alternative.
Yes.
Have there been any cases there that have involved the deportation of foreign criminals rather than simply the return of failed asylum seekers? I'm just wondering if issues about the conduct of the applicants have ever been relevant in
well, they obviously wouldn't be to the primary question. We know that from Chahal and so forth.
Yeah.
Can we check? I'm not aware that there are.
Yeah.
We'll check, my Lord. So we say, my Lord Jones, absolutely was Mr. Malik's case. It could not have been clearer, actually, that it was his case. And that submission and its acceptance, we say, is contrary to the scheme of the Refugee Convention and the Qualification Directive. We agree it's the same test, or the parties agree it's the same test under Article 3. And we say that no court or commentator anywhere in the world, as far as we're aware, has ever endorsed that test. So that is what we thought we were challenging. There's a separate question, which is that standard of undue harshness met in all the circumstances on the case? That's a question which concerns a question of fact. How much hardship would the applicant face on relocation? And we accept that criminality, like anything else, in principle, may be relevant to that question. And that is completely uncontroversial. We make the position very clear in our case at a number of junctures. For example, at paragraph 45, we say the Court of Appeal approach is about the level of harshness the individual can be expected to bear.
So in what way does criminality become relevant?
Mr. Malik gives a number of examples. It could be, let's say you're going to, I don't know, Singapore, and you can't get a job because of criminality here. Or Mr. Malik's examples are he sets them out at paragraph 47 of his case, where he says, apart from the employment example, a person who's just committed sexual offences against children may be susceptible to attacks.
Yeah.
A female convicted of soliciting may receive undue and adverse attention, it should be, says attraction. So that would be...
And you're accepting also it goes to the character and resourcefulness of the individual.
Well, that's his point. The difficulty for him on that point, I'll come to it.
Yeah.
And your lordship may be remembering the Sandbar case.
Yes.
The difference in Sandbar cases, there was a specific finding by the upper tribunal that the individual offending showed his resourcefulness. The finding here is the opposite.
But as a matter of principle,
As a matter of principle, yes.
you accept that it can go to his an assessment of his character.
Practically any... Well, that's not really... yes, I suppose his character in the sense of what would it be like for him there. Yeah. So, question 2, what level of hardship would he face, rather than question 1, the normative question of what kind of hardship should he be expected to bear?
Yeah.
So you would say, would you, that if a person was a particularly accomplished criminal, he might be expected to be more resilient and to survive in uncomfortable circumstances?
I would accept that as a matter of principle, yes, because everything's relevant. But that's not what this case is about. The robustness of character point was never advanced by the Secretary of State at any point in these proceedings. She doesn't actually advance it here under issue A. There's a flirtation with it in issue C about very serious obstacles to integration in Jamaica. That's where it comes in the case. As I said, there's a flirtation. On issue A, she doesn't even say that under issue A. And there's a very good reason why there is that reticence, we respectfully submit, on her part to advance this. There is no finding on that. And indeed, the evidence which the first-tier tribunal accepts is very, very, if I may say so, careful, detailed, and if I may say so, a powerful report, 163 pages, from a medical expert who said that this is a brutalized, terrorized man who is extremely vulnerable, who suffered atrocity, and the consequences of deportation for him in Jamaica, quote unquote, would be catastrophic. He would not be able to cope. So a finding about robustness of character, of course, the Secretary of State doesn't engage with any of that. And that is a report that was accepted. Indeed, the tribunal placed substantial weight, quote unquote, on that report. How could it possibly be said that that is relevant here, robustness of character?
You say the Court of Appeal wasn't addressing that question. It was addressing a question, it was delivering a moral judgment.
It was addressing the question of principle, absolutely. The normative judgment, the normative issue, moral issue, if you like. What is due to you? What are you coming, given that you've offended here?
If you take the Article 3 case law as establishing that the relevant question is whether internal relocation is a viable alternative which would avoid a real risk of treatment contrary to Article 3, you can see that in the examples that are given by Mr. Malik in paragraph 47 are examples where the criminal behaviour has a bearing on the viability of the alternative.
Yes.
If you want to go beyond that, you'll be asking the court to accept that even a non-viable alternative
Yes.
is acceptable if the person's criminality is sufficiently serious.
Exactly. Yeah, that's the problem with the argument that was put, and with great respect with the court's decision below. Can I please take you to the Court of Appeal's decision? In the weeklies, it's at 2499. If I can, for those of you, the other version, if I could just give you the paragraph numbers, 37.
So did you say 2499?
2499.
Our bundle goes up to 2498. So I think this must be a separate bundle.
The bundle of additional authorities. I understand, my lord, my lady, you now like soft copies only for understandable reasons. So, am I wrong about that? We've got hard copies as well.
Yes, but as it was the judgment, I thought I would need to have it in hard copy.
Yeah, we've got it in our additional bundle.
Would you like hard
page
copies?
3?
We've got it. We've got it in.
We've got it. But in the weeklies.
Yes.
Well, if you're offering,
I can offer you a weekly version.
if you're offering copies, then at least I will gratefully accept one.
So, sorry, there are 4 items here. The first one is the weekly. Have you got 5? I'm sorry, my lady. I should have had this to begin with.
Paragraph 37, you would?
My lord, yes. Paragraph 37, thank you, my lord. And electronic, it's 2499. Paragraph 37. So it also challenges that tribunal's value judgment on the basis that SC's criminal convictions are a relevant factor which was ignored. She submits that, and this is a key sentence, submits that criminality may turn relocation from what would otherwise be unduly harsh consequence into a consequence which is not unduly harsh. That's my Lord the President's point.
Yeah.
It's the turning into.
Yes, I was putting it in terms of viability rather than undue harshness.
Sure.
That language is coming from Rule 3390, is it?
Sorry. Unduly harsh is coming from the case law. It's coming from Yanuzi,
Oh, right.
which interprets unreasonableness to mean unduly harsh as a way of indicating that the threshold is high. It's
Yes,
stringent or rigorous.
Yeah.
And then 39, third sentence, this may change nothing. Indeed, it's difficult to characterise what circumstances an unduly harsh consequence may be turned into a consequence that isn't unduly harsh. So it's the same consequence being turned into something else. And then at 40, this is a critical paragraph, you can frame the third question this way: is it unduly harsh to make SC move to another place in Jamaica where he'd be safe rather than letting him stay in the UK? That suggests that something inappropriate is being looked at. The idea is there's some sort of cost to the host state. That is relevant in the Article 8 context. It's not relevant in this context. And the next sentence, the phrase unduly harsh imports a value judgment of what's due. So that's the moral judgment, if you like, my Lord, Lord Jones. It's possible to postulate that what may be an unduly harsh consequence for one person may not be an unduly harsh consequence for another person, where the latter is a person who represents a dangerous community because he's committed serious crimes. And last sentence, his criminality ought to have been considered. It wasn't. And next paragraph, does this vitiate the finding? The tribunal did not weigh criminality in the balance. So that all makes it very clear that it's question 1 the court were deciding, not question 2. Question 1, criminality is relevant to the standard that you have to meet, not simply relevant to whether you would meet the standard. And that is made very clear by the Secretary of State's original skeleton and her replacement skeleton. Can I just take you in the clip that I've given you, please, to page 2521. So it's a first item in the clip that I've given you, paragraph 17. So this is Mr. Malik's permission skeleton. He submitted a replacement skeleton subsequently. Paragraph 17, ground 1 concerns the proper approach to internal relocation in light of Yanuzi. This raises a question as to whether the test stipulated in Yanuzi imports a balancing exercise requiring the public interest to be weighed against the circumstances of the individual, or the focus is solely upon an evaluation of the consequences and impact upon the individual.
Sorry, the paragraph again, please.
17.
Thank you.
Middle of the page, my lord.
Yes, thank you.
Do you have it?
Got it.
So it's the second half of that paragraph. Does it import a balancing exercise requiring the public interest to be weighed against the circumstances? His case. Or is it simply evaluation of the consequences and impact? Our case. And then he argues for that at paragraph 27 at 2526, and he says the FTT gave no consideration to the seriousness of his criminal offending. There was no balancing exercise requiring the public interest to be weighed against the circumstances of Mr. Clark. The focus of the FTT was solely upon an evaluation of the consequences and impact upon SC of internal relocation in Jamaica. Now, that I think isn't defended. And it's now argued that it didn't conduct an evaluation of the consequences and impact by reference to criminality somehow. And in his replacement skeleton, again, we see a similar idea at 616. There's paragraph 23. Secretary submits that one cannot exclude altogether the criminal conduct of that person. Legally relevant consideration, so not factually relevant, legally relevant. The phrase unduly harsh is ordinary expression. What is due or undue depends on all the circumstances, i.e. it goes to the standard, not whether it can be met. What is due? What have you got coming to you, as it were? And then over the page 24, paragraph 24, middle of the paragraph, it, put another way, not at all difficult to see that what may be an unduly harsh consequence for a person who is law-abiding may not be an unduly harsh consequence in the case of a person who, by reason of committing serious offences, represents a danger to the community. So is that normative point that is being pressed, not the factual one, but your character and circumstances as evidenced by your criminality may mean that you can meet the standard or you can't meet it. Not that at all. And then at 25, just below the page, it may be undue to require a person with no criminal record to return to a safe haven in a country which he's not been for 15 years. However, it may not be undue if that person is a serious criminal. Again, because the standard becomes different, not because it means that criminality makes it more or less difficult for the individual to meet that standard. Now, let's, as I said, unclear to us when we read the Secretary of State case whether she was actually defending it. It appears she's not, but I just want to very briefly say to you, advance 5 reasons, if I may, why the test, as it was accepted by the Court of Appeal, as it was advanced by the Secretary of State, it is fundamentally wrong in law. And there are 5 reasons which we advance in our case at paragraph 49, EF 68. The first reason is that there's an inconsistency with the basic scheme of the Refugee Convention and the Qualification Directive, except there isn't that with Article 3, but I've made submissions to you about why it's essentially the same test. And if it's got to work for the Article 3 context, it needs to work in the Refugee Convention. We've seen that the court was interpreting Januzzi, which is a Refugee Convention case.
Yeah. In connection with that, can I ask you, Januzzi, you adopted the expression unduly harsh, which had previously been used by the Court of Appeal in Robinson, taking it from Canadian case law on the Refugee Convention.
Yes.
And
I'm very impressed with the lightning speed with which my lords picked this up.
And A.H. Sudan is another example of the same type of case.
Yeah. In fact, A.H. Sudan is 3 of the Sudanese appellants coming back in Januzzi.
So these are all cases about essentially failed asylum seekers being sent, whether they can be sent back under the Refugee Convention, whether refoulement is possible.
Exactly.
Now, in KO Nigeria, the phrase also appears, but there it's because it found its way into statute in exception 2.
Exactly.
Which isn't relevant in our case.
No, you're absolutely right.
So is this the first time we've had to look at this expression in a case that is neither a refoulement case nor an exception 2 case?
Well, we would say it is a refoulement case for the reasons I gave before.
I see. Right. Yeah. Well, it's not the Article 3 case can't be characterised in that way, I don't think. But your case based on the Secretary of State's policy, on your interpretation of it, could be.
Yes. If your lordship is against me on my submission by reference to Strasbourg jurisprudence, yes, I can see. Refoulement under the Refugee Convention is return to persecution. In international human rights law, it's broader. It's refoulement is also. That's what I meant.
Yeah. Well, I thought I might be making a point in your favour, actually, so far as Article 3 is concerned. We saw the language in the cases talks about the viability of internal relocation, or whether it's realistic or reasonable. The language doesn't introduce any idea that there is some sort of merited level of difficulty or hardship.
No, none at all. No, the metric is, well, the context is of it. As the Strasbourg court says, if you remember, it said internal relocation involves a certain degree of hardship. Mm-hmm. So that's what we're looking at. And given that the context of the Refugee Convention one might say, well, what's the metric is, well, how much difficulty would a person with well-founded fear of persecution in a local area face, right? Now, with the focus being somebody who has a well-founded fear, you need it to be persecuted. You don't say, well, everyone in this cohort has been subject to repeat rape, for example. You meet the definition if there's an apprehension of risk. So, but absolutely it's got nothing whatsoever to do with the host state's interests. And the point I'm going to make on the first reason why this is so wrong, so fundamentally wrong, is because when you've got host state interests, they're directly addressed in the Refugee Convention itself and under the Qualification Directive. And that forms part of the context of interpreting the treaty, of course, and the context basically comprises a carefully calibrated scheme for taking into account criminality. So the Refugee Convention, to begin with, if I can take you to that, it's in that clip I gave you, because the earlier entry was incomplete. So it's Refugee Convention is looks like this. You've also got it electronically, I hope. It's 2535. You won't have it in the original funding, but you were given it electronically. So these are extracts from the Refugee Convention. You'll see Article 1F. Some of my lords, my lady, will be very familiar with this. So the provisions of this convention shall not apply to any person with respect to whom there are serious reasons for considering that crime against peace, serious non-political crime, acts contrary to purpose and principles. You've got the definition 2 pages earlier, which I could just perhaps show you, because if I was going too quickly on where IFA, the Eternal Flight Doctrine, sits in the text, you'll see Article 1A, for the purpose of the present convention, the term refugee shall apply to any person who, and we delete the temporal limitation in 1967, owing to well-founded fear of persecution, is outside. That's where Lord Bingham located it. His country of nationality, and is unable, owing to such fear, unwilling to avail himself of the protection of that country. That's where Robinson, the EU earlier on, Hathaway, New Zealand located. But 1F, so that's exclusion. So that, my lord, negates your status as a refugee. If you come within 1F, you're not a refugee. The provisions of this convention don't apply to you. If we carry on, the rest of the convention is directed to what rights refugees have. And Article 28, travel document, you get that if you're a refugee lawfully staying, unless compelling reasons of national security or public order otherwise require. And in 32, Article 32, you can't be expelled if you're a refugee lawfully in the territory, save on grounds of national security or public order. So that expelled not to somewhere else, to a third country. If you've been admitted as a refugee and granted leave, then you can't be sent to any other country. And then 33 is the most important provision, except that's the non-refoulement. That is then negated, that right is negated if you're into a final judgment, particularly serious crime and constituting a danger of the community to the country. So that's the Refugee Convention. Qualification Directive makes similar provision. The point of showing you this is to show you what the scheme is, how the scheme deals with criminality. And Qualification Directive is at is at EF 717, electronic. And we've got at 725, sorry, I should just show you Internal Protection, Article 8721, that's what's transposed in the rule. the may in the article becomes a will in the rule. It's permissive. Article 8 is permissive. Member states can and may invoke internal flight as a reason for negating, which is a throwback to the fact that some states don't. France doesn't. France doesn't invoke internal relocation, generally speaking, from our researchers. We will, and we've seen that in transposition. And then family reunion, Article 23.1, member states shall ensure family unity can be maintained, and then 4, member states may attenuate the benefits for reasons of national security or public order. So this is a benefit accruing to a refugee or someone who's beneficiary of subsidiary protection that is then attenuated through criminality. And the same point over the page 726, residence permits 24.1, 3 years renewable unless compelling reasons of national security or public order. And same point at 25, travel document unless compelling reasons of national security or public order. And we say the Court of Appeal's approach subverts this careful scheme. You could lose all the rights to which you're entitled, all of them, not residence permit, family reunion, travel document, non-expulsion, but everything, if the Court of Appeal is right, and what would otherwise be an unduly harsh consequence for you is quote-unquote turned into something that's not by reason of your criminality. And at 53, in our case, we make a similar point about cessation. Your status as a refugee can be ceased. My Lord Hamblin may recall the MS Somalia case where this issue arose. MS Somalia is at EF 925. I don't need you to take it up at all. But the issue in MS Somalia was, well, can the Secretary of State invoke cessation because there's become an internal relocation alternative where previously there wasn't one? And the answer was yes, she can, if the change in conditions is significant and non-temporary. And in that context, it was interesting that the reason why cessation was invoked was because the individual had committed criminal offences, as here. That was no part of the analysis, though. It wasn't argued, as it may have been if the Court of Appeal is right, that what was previously an unduly harsh internal flight alternative became reasonable because of the individual's offending, and he was described as a very serious and persistent offender. And indeed, in this case, we've set it out at 53, the Secretary of State said that we don't apportion any weight to an individual's conviction when considering whether cessation is appropriate. That is set out at paragraph 53 of our case. It's paragraph 9 of the Secretary of State's cessation decision, which you will find at EF 63. And that was perhaps in response to the UNHCR saying in this case that there's a danger precisely of invoking criminality as a trigger for cessation. What happens that is compatible with law is that criminality is the occasion to review refugee status, but it's not a ground. It doesn't form any part of the ground. The Court of Appeal's approach makes it a potential ground to cease status. It creates an additional basis for cessation, even where there isn't a change in country conditions. So it permits cessation on the basis of offending by the back door when it is not permitted through the front door. So that's perhaps the most powerful case against the Court of Appeal's conclusion and the Secretary of State's argument as then advanced. But then there's also a profound lack of support in domestic authority for this idea. The Court of Appeal, as my lords will see, my lady will see, based itself on the generous wording in the UKSC case, where all relevant circumstances are to be looked at other than conditions in the home country. But that was directed to measuring the impact on return of local conditions in light of particular circumstances of the individual, to see whether the standard is met. It's about impact. And we submit that the Secretary of State cannot point to a single case, and in fact doesn't do so now, it now seems, where criminality operates to heighten the standard. And we've given you, we've extracted certain passages from the cases. I can give you references if you would like. I can also take you to them. I don't think I need to take you to them. But the fundamental point is that the test, a touchstone of which is, can you live a relatively normal life, judged by local standards that prevail in your country of nationality? That just is inconsistent with this idea that you make a moral judgment about what's due to the individual. And so 56.1 EF70 is Januzzi, Lord Hope, and then over the page, the E case, which my Lord, I think, mentioned, H. Sedan, and so forth.
Can I ask, yes. I'm wondering why people are still using the expression unduly harsh. That's an expression derived entirely from case law, yes, on the Refugee Convention. We now have legislation in the form of we have the Qualification Directive implemented in domestic law. It's, I think, by the rule 3390.
That's right.
And they both, none of them talks about unduly harsh. They ask whether the person could reasonably be expected to relocate.
Yeah, that ought to be the test. That the case law has said it's reasonable in the sense of undue harshness. But the governing test is reasonableness. I would accept that it's still a demanding test, even if it's reasonableness. It would make it more difficult, at least linguistically, for this kind of moral judgment to enter the equation. One of the reasons why the Court of Appeal felt able to accede to the Secretary's submission is because of this idea of what's due. What have you got coming to you? Sorry if I'm labouring the vernacular a number of times. Apologies. But absolutely, the paragraph of Rule 3390 is retained EU legislation under the 2018 Act as amended. Mal-leasing is case law that's retained. It's also a general principle, effectiveness. So absolutely. And then the second set of points that we make about domestic case law is from KO Nigeria, the case that Your Lordship referred to.
Well, that was a very different situation because, I mean, that's using the expression unduly harsh, but it's in the context of whether the removal of the parent would be unduly harsh on the child or on the partner left behind.
Yeah, absolutely. The reason it's interesting is because one of the reasons why Lord Carnworth said you shouldn't weigh in the balance criminality is because it would subvert the scheme. That's one of the things he said. And that's relevant of the main argument that we make here. The other reason it's interesting is because he actually noted cases at the tribunal level and Lord Justice Laws, my Lord Hamden was in the case as well, Uganda, where he said, look, we think you balance in this context, but refugee law is different. And Lord Carnworth suggests that's the case. Can I take you to KO Nigeria just now, briefly, because it's also very important for my argument in issue C and D.
KO Nigeria is a case concerned, as I understand it, with exception 2
exactly.
in the statutory scheme. Now, before we go to it, is the interpretation transferable to the different context? You rely on it. They're the same words. But
the reasons why Lord Carnworth held that you don't weigh the public interest in the balance are transferable. The reasons why, because one of the reasons is transferable. One of the reasons was that you subvert the statutory scheme, and we say
that you've already taken it into account. It's already been brought into account in other ways within the scheme.
The public interest, absolutely, has been set by Parliament already, because Parliament has said that you've got to hit this threshold to counterbalance the interest in deporting you.
But that depends on that particular scheme relating to exception 2.
Sure.
My question is whether as a result,
no,
the reasoning is transferable.
It's not my strongest point in this case. I completely understand that. All I'm saying is, if my first point is bad, this doesn't add anything. You're absolutely right. My first point is, the Court of Appeal test is inconsistent with the regime of the Refugee Convention and the Qualifications Directive. And if that's a bad point, KO Nigeria doesn't add anything on that point. But I want to take you to it.
I don't want to stop you taking it.
Just because it's important for the submissions I'm going to make, I hope not too far away. So KO Nigeria is 899. And Lord Carnworth's judgment begins at 9:06. The issue in the case is set out at 9:08, paragraph 6. Can I actually just go to paragraph 4, where he sets out section 117C, and I hope you understand why I'm doing this in about 20 minutes' time. It's convenient to just do it now. So he sets 117C out. One, deportation of foreign criminals
where are you finding 117C?
907, bottom of 907.
Paragraph 4.
Thank you.
And the reason I wanted to show you this is because the debate concerned the impact of 2, subsection 2, in these cases. My Lady Arden, my Lord Hamlin may recall, they're involved in some of the cases. The question was, subsection 2, the more serious the offence committed by a foreign criminal, greater the public interest in deportation. Was that by way of preamble, or was it governing of that which followed? And Lord Carnworth held it was preambular rather than governing. Court of Appeal had held it was governing. And that's really important when we come on to our case on issue C, because I'm going to submit to you that the Court of Appeal went wrong on exception 1 in thinking that 2 was governing. Indeed, again, that was Mr. Malik's express submission. He said 2 governs exception 1, and that is the best way of understanding with the greatest of respect, I may say, is a rather opaque section in the Court of Appeal's judgment with the greatest of respect. So, and then paragraph 12, general approach, this is EF 910, where Lord Carnwath sketches the general approach. At 14, he says that the relevant part of the Act expresses the intended balance of relevant factors in direct statutory form. And then the summary conclusions, and this is the critical part of the judgment set out at 9:12 to 9:13, beginning at 21. So the structure isn't entirely easy to follow. And then 21, this is the critical point for us, the preambular governing debate. Difficult question is whether the rules allow for any further room for balancing of seriousness. The general rule in 2, subsection 2, might lead one to expect some such provision, but it could equally be read as no more than a preamble to the more specific rules. Exception 1, that's us, seems to leave no room for further balancing. Mr. Malik was arguing it did. The Court of Appeal appears to have thought that and set aside the first tier on that basis. And then 22, exception 1 is self-contained, etc. And then the other part of this which is interesting is that I've lost the reference. Where Lord Carnwath just reviewed a tribunal case at 28, where the tribunal had said, you don't balance undue harsh, and because you don't balance it in asylum claims, 915 letter C. So the MAB tribunal was saying, you don't balance unduly harsh, just in the same way you don't balance unduly harsh in asylum claims. And then Lord Justice Laws in Uganda, my Lord Hamblin may recall, 31, that subsection I showed you was at the heart of the key passage. And over the page, 916D, he found no assistance in parallels with the use of the same term in refugee law, since the asylum context was far removed. So he was saying in Uganda, you do balance under the Act, and that's far removed from asylum, so you don't get anywhere with that. Now, my lords, that's what I want to say about the domestic authorities, my lady. And then state practice, we have summarised in our written case at 67 through to 71. No support whatsoever for the Court of Appeal's test, with great respect. And we make the point that given that state practice is the genesis of this doctrine, that is very significant, and we would, with great respect, be an outlier if my lords, my lady, accepted this test. There is debate about, as I've said to you, where you put the doctrine in the Refugee Convention, what you label it. There's a debate about what the standard is. But no one has ever suggested that you elevate the standard by reference to criminality in the host state. And in the clip, we've got an ILC report on subsequent state practice, if my lords are interested in that. We just extracted the relevant section, which helpfully reviews WTO, ICJ, ECHR, and comes up with a conclusion that state practice under 31(3)(b) VCLT can take a variety of forms, got to reflect a common understanding of the parties regarding interpretation. Its value as a means of interpretation depends on the extent to which it is concordant, common, and consistent. This view is discordant, uncommon to the point of being unique, and inconsistent with everybody else. That if you want the reference, that's an ILC report at 2542. No, that's where it begins. The conclusion is at 2548.
Can I ask, Ms. Hussain, you've shown us Lord Carnwath's analysis of
Yes.
exception 1 in paragraph 21 of KO Nigeria, and we can see that there's no issue about undue harshness in relation to exception 1. The question is whether there are very significant obstacles to integration. Now, am I right in thinking that in your submission the applicant qualifies under exception 1?
Yes.
Yeah.
Yes, the tribunal found that very clearly.
And if he does, that's the end of the story.
No, because, no, you're right. It is because, the question is, would he get any more by way of leave if he succeeded in his Article 3 case, as opposed to Article 8? I'm not sure he would. Your Lordship's right.
So there would simply be no obligation to deport him under the statute.
Correct, my Lord.
Yeah.
So we also say that in our case at 72 to 73, there's no support in, sorry, not 72, 73. No, I had that right, apologies. The lack of support in the commentators or experts all advance the same a basic approach, common minimum standard you have to have in your internal flight area. Personal characteristics relevant to whether the standard is met, not to what the standard itself is. And the last point that we make at 70, I would put it too high, I apologise. We say at 79, EF 79, paragraph 74, we say it's unbounded and unworkable. It's too high, it's unbounded and difficult to work. And the reason it's difficult is that if reprehensible conduct in the host state can alter what the standard is, then so can worthy conduct. And it is a decision maker really to look at how much a refugee has contributed to volunteering in the pandemic, or have they invented the BioNTech vaccine, for example, if you're looking at cessation. Is that really what this is about? We say the answer is, with respect, absolutely obvious. It becomes difficult to apply. So those are my submissions on issue A. Issue B, we address in our case at paragraph 78 to 103. I'm just going to take this relatively quickly. This is at EF 80 to 87. And perhaps I can do it by reference to the Court of Appeal. The Court of Appeal set the relevant questions which my Lord Stevens adverted to earlier at paragraph 33. So that's 2507 of the additional bundle in the weeklies, but paragraph 33. So three questions. What's the location? Are there risks there, if not reasonable? And then it criticised the tribunal on the basis that its conclusion was reached without proper analysis and evidence. That's 35 and 36 of the Court of Appeal. So it said, first of all, no consideration of any other part of Jamaica other than Kingston, no analysis of whether the rest of Jamaica, rural or urban, is homogenised or differentiated in terms of risk, the need for medical evidence as a relevant factor was relied upon, but without analysis of evidence as to whether the medical treatment could be continued elsewhere or whether that would be inadequate, lack of employment opportunities, no evidential foundation. Now, we respond to that, firstly, by addressing the first two questions. Where do we go, and is it safe? And we say the first point to note, this is paragraph 83 of our printed case, is that there's no question of burden or standard of proof here. That's Karanakaran. We've given you their reference to that. And the EF reference is 759 to 760. Now, the different views about the burden, in our law, there isn't one. One view is that the burden should be on the applicant because this is part of the refugee definition itself. The contrary view is no, it's on the state because this is a response to a claim. He who asserts should prove. The claimant would have to prove a negative. And there is an obvious asymmetry in access to information. The UNHCR hold that view at EF 715 to 716. The Secretary of State had raised the issue, but in only general terms. We've set it out at paragraph 84, and it was by reference to where the mother's activities of a decade ago weren't known. The reference is EF 795. And the result, as we put it at paragraph 85 of our case, was the first two questions were linked. The FDT had to search around, try to work out if there was a place, any place, because it hadn't been identified, that would be safe. And the conclusion was that he would have to relocate to a rural area to avoid the general population. The upper tribunal thought that this was a legitimate conclusion because it couldn't be considered in isolation. I'm at 86 of my printed case. The background evidence showed that there was widespread discrimination against LGBT people. She'd accepted that this extended to family members in this case. And we respectfully submit that that's absolutely right, because with what great respect the Court of Appeal missed was that the starting point for the tribunal's consideration of this was the adjudicator's decision given over 10 years previously, where the adjudicator had specifically accepted that the gangs who raped, abused, and attacked the appellant's mother had done so in many, many parts of Jamaica, not just Kingston. It accepted that she'd gone into hiding in the countryside to avoid being ill-treated, but it returned to Kingston because most of the members of certain groups, in particular the most vicious of them, sought them out. So this was very much a countrywide problem as a starting point, and we see that. But I'll just give you two references. It's paragraph 11 of the adjudicator's decision. I do mean adjudicator. It's the last document in your core volume, EF 178, and paragraph 11 is at 180. That's her evidence, where she's saying she went into hiding in the countryside, came back, she was following the countryside, and the adjudicator accepts all of that at paragraph 36 at 184, EF 184. At EF 185, for good measure, the adjudicator accepts that she's been followed here. Sorry, not followed, that's wrong. Recognised here by some of her persecutors in the UK. And that refers to a passage at paragraph 17. Sodomite, I'm not going to say the name, you're not dead yet, you must die. Bottom of page EF 180. And then there was very extensive evidence that Jamaica was virulently homophobic, and the tribunal judge noted that the Secretary of State did not argue that the position had got any better, and we see that from paragraph 33 at page 171. So again, when the tribunal turned to look at Article 3, they take as a starting, the FTT judge takes as a starting point the success on the mother's appeal. And Mr. Norton is the Secretary of State's presenting officer, so he doesn't argue that things have got any better at all. Mr. Malik raises an issue about state protection. He wants to raise a new point about state protection. We say it's not open to him, but even if it is, it's with great respect a thoroughly bad point, because the adjudicator's decision traversed issues of state protection at paragraphs 39 to EF 184 to 185. So 39, not sufficient and effective protection for this social group. Police are not able nor have the will to come to the aid of this social group, and so forth. And then the Horvath standard is applied. So things not any better, Secretary of State's position. And the tribunal accepted that at 35 to 36 at EF 171 that the risk extended to her son, because in Jamaica friends and relatives are persecuted. There had been attacks on her mother, her sister, her brothers had been shot trying to defend her, and so forth. So the threat extended well beyond Kingston. To avoid persecution, he would have to move to a rural location, as the mother had done unsuccessfully. And this was indeed to avoid the general population, because the threat wasn't just limited to gangs on the objective evidence, but the general public, anyone who would become aware of his history. And the baseline, we say, is that this is a countrywide problem. Secretary of State's operational guidance note, in fact, accepts this. It's a countrywide problem. I don't want to take you to it, but it's a EF 526 to 527. So we say, well, the upper tribunal were correct to say that this was a reasonable inference for the tribunal to draw. It said this at EF 163, paragraph 14. And we say the FTT can't be criticised for failing to identify a specific location when it hadn't been identified. And there was no need for the FTT to conduct an analysis about whether risk was homogenised or differentiated. The conclusion that only rural areas were safe adequately addressed the evidence and submissions. And the key thing, as I've said before, that was missed is the extent of the adjudicator's findings, the extent of the ill treatment directed at the family, the Secretary's concession that things weren't much better, and the Secretary's own case that you need to relocate where your mother's activities weren't known. Well, she was followed into the countryside. On the third question, reasonableness, we address this at paragraph 90 to 103. We say, firstly, that the upper tribunal was correct to say that the cumulative assessment of factors, the FTT conducted a cumulative exercise and was entitled to take into account the matters that she did. The first set of factors were, this is paragraph 38, it's the all-important paragraph of the FTT at 172. The first set of factors is that he would be alone. Only links in Jamaica are Kingston, where he used to live, and grandparents neither remain. He's not been there since 2001, etc. That's uncontroversial. It's part of the personal circumstances of the individual. The second set of factors is that he is deeply traumatized and in need of long-term treatment. Now, this was drawn from the evidence of Ms. Krause, the report that I previously referred to which the FTT gave a substantial amount of weight, quote unquote, substantial amount of weight, bottom of 169, paragraph 25.
Couldn't actually see what the treatment was that he requires.
I'm sorry?
I couldn't understand exactly what the treatment was that is required.
I think she had said that he needs intensive psychotherapeutic treatment in conditions that were safe, which he'd never had in prison and no other institution had given him. Ms. Crowell, we summarise at 93 to 94. So she concluded that he was suffering to a very severe degree. So I'm in 94, I can give you the references as well. Very severe degree from complex and chronic form of PTSD. That's 365. Among the most vulnerable clients with whom she'd ever worked. That's 449. His symptoms had caused significant distress, acted to impair his social function. That's not, the reference is wrong there. It's not 616, it's 6116. At 370, his psychological profile had extensive implications for his capacity to cope independently and for his vulnerability to various forms of further harm. 397, when exposed to circumstances causing an upsurge in intrusive recall, cognitive ability grossly impaired, ill-equipped to cope with situations. That's 397. And that, we say, was of obvious relevance to the reasonable of relocation to a site where he had suffered atrocity. That second finding was also, and that's not answered by saying, well, you can go to the countryside. She said, you go to Jamaica, this is going to trigger him in the most dramatic way. The word she used was it's catastrophic for his already fragile mental health. Second finding was supported by, talked about the need for treatment. The references there in our case at 95 are EF 276 and 405. The Court of Appeals criticism of this, we say, is unfair because the issue wasn't, well, is treatment available in the countryside? Is it adequate somewhere else? The point was, he can't access, he's in no state to access it there. And we make that point at paragraph 96. The expert had concluded that he required very long-term, highly specialist treatment in the context of consistent, safe and stable support. That's at 276. Absence of which his mental health and social function will deteriorate. He would not be fit to engage in any treatment until he was in safe and stable environment. That's 402. And the Secretary of State, we say, appeared to accept that, in fact. She made it clear that the mere fact of return, quote unquote, would be nothing short of catastrophic for his mental health. That's at 409. Because it would involve a return to the site of his childhood trauma, loss of existing support networks. Not only would his symptoms worsen, this is 409, 4010, he would also be unable to access any help or support. So on any view, in fact, if the first-tier tribunal had said, well, he could access statement, that would have been, with respect, a perverse conclusion, having accepted this expert's report, given special weight for it. It's impossible to see how that finding, as part of the conclusion that relocation would be unreasonable, unduly harsh, can, with respect, be criticised.
Can I ask you, Mr. Hussain, before you move on to something else? We were looking a few minutes ago at section 117C. And that's one of the provisions that was inserted into the 2002 Act by the 2014 Act.
Yes.
Does it apply to this appeal?
Yes, there's a case called VW Uganda, which held that it did. And the tribunal had regard to it. And I think the tribunal cite that case. Right. Sorry, they cite that case for the rules, but then, yes, the Act applies because it directs any tribunal considering any question.
There was, I know that there are equivalent provisions in the immigration rules.
Yes.
Yes, there used to be.
There are.
Did they come into force at the same time, or were they already there?
I think they were just already there, but the case that I mentioned says you've got to apply the current rules. Lord
right.
Justice Leggett, in a case called CI Nigeria, said really you should look at the Act for obvious constitutional reasons. It's the same, it's the same provision.
Thank you.
Yeah, Mr. Cox reminds me it's Y, not VW, YM Uganda. I have trouble with the letters.
Sorry, Y?
YM Uganda, paragraph 41, FTT, EF 172. Thank you.
Thank you.
On employment, which was the last factor, we addressed that at 99. We say this is something that the tribunal, as a specialist tribunal, was permitted to have regard to. And indeed, Karen Ackland establishes that the only thing that you can discount is something that you've got, only if you've got no real doubt about something can you discount it in this holistic assessment. And we say it was perfectly proper for the tribunal to reason, well, employment opportunities would have been concentrated in the capital. Those factors generate the conclusion that he was likely to find himself unsupported, homeless, destitute, unemployed, in need of psychological treatment. A lot of it flowed from his quite appalling mental state and the catastrophic effect of return.
What paragraph 41 says is that, owing to the judgment in YM Uganda, I have applied the version of the rules, capital R, which postdates the changes made on 28 July 2014.
Yes.
So it looks as though that's dealing with the immigration rules.
Paragraph 51, my lord, EF 173, the
51.
Act. Paragraph 51, that's the Act. And then, my lord, just going back to the IF internal flight conclusion.
There must be a transitional provision or commencement order which
yes,
governs this.
There is.
You can no doubt let us know what it is.
I will. So, my lord, employment, we say 101, even if you exceed or agree with the Court of Appeal's criticism of the finding on employment opportunities, the first two factors, need of treatment, being alone, are more than sufficient here, given essentially the medical evidence. And that's the point we make at 101. And there's no, and then 102, some general material on the standard of review, etc. So that we say is why there was nothing materially wrong in the FTT's point. The new point that Mr. Malik raises, I'll address in reply. We say there's no merit to them, and one of them certainly should definitely not be permitted to be argued. That's the point about, well, there was the sufficiency of protection conclusion was unlawful, a point never argued before, not argued before the FTT, where my client could have produced more evidence, not argued before the upper tribunal, not argued before the Court of Appeal. Difficult to see why it's somehow being argued now, but we're very happy to address it on its merits, de bene esse, as it were. Article 8, my lords, in the time I've got left. So I've taken you to the relevant provisions of the Act and the idea that the relevant subclause 117C2, the debate about whether it was preambular or governing, we see that that is quite important for how the Court of Appeal deal with this issue. They begin their consideration at paragraph 43. And at 52, they identify 3 issues. The first 2 are resolved in our favour. There's no appeal against them. Issue C suggests that the Court of Appeal thought that 117C2 was governing, not preambular, and that the public interest in deportation had to be weighed in the balance when deciding whether exception 1 was met. Indeed, that was exactly Mr. Malik's argument. If you look at EF 622, at paragraph 37, Mr. Malik argued at 47, this is the very serious significant obstacles finding. The FTT based the conclusion on its findings that no family hadn't been there, was a victim of torture, in need of very long-term specialist therapy. You might think that might be enough. The plain error of law made by the FTT in this respect is its complete failure to balance these facts against the public interest in deporting foreign criminals. And then Uganda, which of course, my Lord has the point, would concern exception 2, not exception 1. But Mr. Malik was arguing that this applied, quote unquote, with equal cogency, we have that phrase again, to the phrase very significant obstacles. So he is saying public interest should be weighed in the balance on exception 1, at least insofar as very serious obstacles, significant obstacles is concerned. And if you look at the way the court formulate the issues at paragraph 52 of its judgment, the Court of Appeal, they seem to think, well, that is the issue. And 53, they deal with the temporal issue most of his life. 54 to 57, they deal with lawful residence. Doesn't concern us. And then 58, they record the Secretary's submission on the Article 8 question. FTT misdirected itself when it considered whether there were any compelling reasons rather than the correct test, which is very compelling circumstances. That, of course, just goes to the safety net, to 117C subsection 6, the safety net, very compelling circumstances over and above, which the Court of Appeal held also applied to someone like my client. That, on its face, only applies to serious criminals, more than 4 years. There's a case called N.A. Pakistan, my lady recalls, where the court held, well, it must have also been meant to apply to someone who's less serious of an offender. But so there are 2 issues here under Article 8. One, FTT says we meet exception 1. Was there an error about that? And 2, in the alternative, doesn't need to say it, but do we get through on the safety net? Exactly, my lord, exactly. You're absolutely right. N.A. Pakistan is N.A. Pakistan, and in fact, in this court, the Court of Appeal below refer to that at 46, paragraph 46. So 58. So the first sentence looks as though it's directed at the safety net. Even if that were right, it wouldn't touch on exception 1. We say in substance the tribunal had regard to the statutory factors. We say in substance it was very well aware of the importance of the public interest and the seriousness of his offending. It repeatedly said it's his really serious offending. He's a prolific gang member and so forth. And that's our case at 134. I'm sorry to jump, but ahead. And the factors, it considered the factors on my client's side of the balance were extreme, and they were summarised at paragraph 8.3 of our case. We say in substance there was nothing wrong. We accept the point that it said compelling reasons, compelling reasons, compelling reasons. At one point it said very compelling reasons. It didn't say very compelling circumstances. We accept that. There was a misdescription of the test. It only speaks to the safety net, not to exception 1. Going back to 58, Secretary also submits that the FTT erroneously took into account compassionate circumstances, failed to consider his lack of financial independence, and failed to appreciate the weight which is to be placed in the public interest in deportation of foreign criminals. That appears to be directed at exception 1. And the weight in the public interest refers back to Mr. Malik's argument in his replacement skeleton, the skeleton that was live before the Court of Appeal that I already showed you. At 60, the court says you approach it commonsensically. Broadly, 60, this is integration. 61, very serious obstacles, similar approach. And at 62, I need to spend a little bit of time on 62 to 64, because this is the critical bits of the Court of Appeal's reasoning. We say it's very clear that the court was persuaded by Mr. Malik that exception 1 was subject to a public interest weighing, and that is wrong in law. 62. In this case, the FTT didn't analyse the public interest in accordance with the statutory scheme. It treated Article 8 analysis as freestanding outside the statutory scheme. The evaluation is lacking in focus. It failed to give sufficient weight to his criminal convictions because it balances offending against traumatic history rather than against the statutory factors having regard to the test. In any event, the test is misdescribed. That very much suggests that it is dealing with the safety net issue. The test was misdescribed. Compelling reasons versus very compelling circumstances. That is the safety net, the NA Pakistan safety net. 63.
You say the NA Pakistan safety net. This is a recent act of Parliament. The reasoning is based on INCO Europe.
It was, yes, exactly.
That Parliament enacted an absurdity.
Absolutely, yes. But
that's a very it's a rather startling proposition.
Sorry, what is that?
But the parliamentary draftsman came up with an absurdity. And the courts know better and can effectively override what the Act says.
I can argue that if you'd like me to. I've got very little time left. It's common ground. The logic is, if you have this safety net for someone who's committed 4 years...
I know what the logic is, but Lord Justice Jackson gives us his reasoning.
Right. My Lord, 63, the Secretary...
But it assumes that... It assumes that long-term criminals, the relevant factors in relation to them are different from those applying to short-term criminals such as the Appellant.
Yes, the statute makes that. I think the short point, there are 2 points. Firstly, does it make sense to give the serious criminal that safety net and nothing else?
Well, you're assuming that very compelling circumstances are to do with something different from the subject matter of the 2 exceptions.
No, they're over and above. It can be. I think they said it can be the same subject matter. It doesn't have to be something different. It can be the same. And the reasoning was, well, it can't be a closed scheme for the medium offender because he or she may not win on 1 and 2. We did. On exception 1 and 2. Is that it? Is that the end of the inquiry? In circumstances where Parliament intended that section to be compatible with Article 8, you'd have a colossal incompatibility problem there, my Lord.
Well,
already Strasbourg is straining at this Act. My Lord knows from Sanambar
Yes, yes.
submissions I made to you.
Yes, yes, we also know about the importance of giving effect to the intention of Parliament. No doubt we'll hear from
My Lord, if
whether the Home
anything,
Secretary considers that the bill which was put up was absurd.
if anything, the safety net should be less, and we reserved our point on that. It should be less for a medium offender. It shouldn't be the same. But my Lord, I've got about 3 minutes, but I'll continue at 2 o'clock. 3 o'clock.
Can I ask, do we have the rules that are referred to, the 399
We'll get
A,
them.
B, and so forth?
Annoyingly, the one thing we haven't got, I'll produce them. Thank you. They are set out in the Court of Appeal, but Mr. Cox has been given to you at paragraph 16 to 17, 2504 to 2505. And then I'll use 5 minutes of my reply, if I may, at 2 o'clock.
Yes. Would
Would you like the rules now? Or?
they can be handed up to our usher once we've gone off the bench.
Thank you very much, Ronald.